Please allow me now to invite our next speaker, Yvette Cehtel from Australia, lawyer and domestic violence professional.
Firstly, thank you for the opportunity to be part of the discussion about the future of the Convention. I'm the CEO of the Women's Legal Service in Tasmania, and we provide frontline domestic violence supports to women, and we're family violence experts. Women's Legal Service Tasmania is a member of 13 networked women's legal services across Australia, which is called WLST. Our services operate as a special measure within the terms of Article 4 of the Convention on the Elimination of Discrimination Against Women. That is, our services are funded by the state, recognising that women would otherwise be unable to access the law. The result of this inequality is that women do not stand before the law in an equal position where violence features in their relationship. In the post-separation context, experience tells us that the violence in that relationship does not end, it just changes. While we recently received increased funding across our network for our work nationally and a dedicated funding stream from the Commonwealth Government, we remain unable to take on all Hague matters throughout our network across Australia. Like Brazil, as we heard last night, we have geographical gaps in service delivery, expertise and funding, which means we only have resources to take on Hague matters as a network on an ad hoc basis. There are no other gendered specialists in the legal assistance sector to fill this gap in the Australian context. Last year, our network members across the country turned away 52,000 women from our services who required assistance for gendered violence. That was 1,000 women a week in Australia. I will use gendered language as statistics tell us that this is a gendered problem. To understand how the law operates in Australia and why mothers continue to abduct children and have no or low confidence in the law protecting them, I'm going to paint a picture as to how the law and systems response is in Australia, driven by a pervasive culture that normalises gendered violence. And we heard some of that from the Chief Justice of the Family Court this morning. While confidence in the legal system in Australia remains so low, abductions will continue to occur, nor can we view all abductions where they occur in a family violence situation as acts of violence. They are, in many cases, the only protective measure women have left when all other legal options have failed. Now, if I turn to the statistics in Australia, national statistics have confirmed that women are unsafe in their homes, their workplaces, and in the streets across the country. 1 in 4 women are experiencing family violence in Australia. Nationally, as we heard from the Chief Justice this morning of the Federal Court of Australia, through his own Lighthouse project, which was a risk assessment tool that the Family Court initiated and developed and was a great mark of leadership in Australia, showed that 86% of filings in Australian jurisdictions had family violence indications. Now, that is an astonishing fact, and it shows the prevalence of family violence in Australia. But not all of those matters have resulted in people being able to substantiate the family violence in those situations. And by that I mean they're not reported. It's a cultural problem that permeates all of our systems, and this culture drives attitudes, behaviour and decisions that all of us in the service sector contribute to. It's a societal structural problem, which I think, again, one of the Brazilian speakers spoke about on the opening of the forum. It's entrenched in all of our systems, and none of us are immune from it. It's therefore wrong to assume that everyone comes before the law equally. So what does structural inequality look like over the life cycle? I had prepared some PowerPoints, but they're not coming up, so they'll be available after this. But it really is a trauma on a trauma on a trauma on a trauma. And I have a diagram in the slide that shows that across the life cycle of girls' and women's experiences generally. This makes engaging with any system difficult. It impacts the way women give evidence and may undermine their credibility. This, coupled with 41% of Australians believing that domestic violence is equally committed by both men and women. This belief impacts police, courts and service responses, and is the reason why so few women trust the police and the courts. Furthermore, in Australia, surveys have shown that 2 in 5 women do not know where to go for help, and that impacts how women engage in the Hague process. So bluntly, the Hague Convention does not recognise the structural inequality that all other international instruments recognise. We are not all equal, and accordingly the legal response, which treats everybody equally, is deficient in a family violence context. Contemporary understandings of family violence requires that family violence and the impact of this behaviour has on women, children, and particular the Indigenous child, need to be taken into consideration as grave risks. I say this because various articles at international law require this approach to be taken. The Convention on the Elimination of Discrimination Against Women in Article 1, which recognises that gender-based violence against women is a form of discrimination against women. Secondly, the Convention on the Rights of the Child, Article 12, requires that the right of the child to be heard in proceedings and in decisions affecting them, and Article 4 requires that best interests to be a primary consideration in determinations. Also, of particular significance in the Australian context is the Declaration on the Rights of Indigenous People, where the Indigenous child has a right to enjoy their culture and know their identity, which is protected by Article 9. That is so important in the Australian context because we've had a stolen generations inquiry called the Wilson Report, and I query how foreign courts with an Indigenous child can determine a cultural context when Australian courts struggle to do so despite knowing the history and having specialist access to Aboriginal and Torres Strait Islander legal services. And in relation to Australian law, the family law system and the state-based criminal laws which deal with family violence and child protection laws are separate. We have a federal structure with a state and territory laws and Commonwealth laws. This fragmentation and siloed approach between the state and Commonwealth jurisdictions fails to protect women and children as they navigate the legal system due to the intersection of the Commonwealth and state and territory laws and the attendant constitutional boundaries. Additionally, which might seem odd for a country the size of Australia, we have different working definitions in each state and territory as to what family violence is. And that differs again from the working definition in the Family Law Act of Australia. So these are all deficiencies in the state-based local laws which undermine the ability of people to access them with confidence. Furthermore, the system response fails to look at the web of all interactions in court, family court, criminal court, and departmental reports, such as child safety and child support, all of which, when looked at as a cumulative pattern of behaviour, may indicate coercive control, in that the perpetrator uses all the legal and bureaucratic tools available to control and coerce the mother through what may appear as legitimate legal exercises of rights. This approach to the law replicates the police practice of focusing on incidents as opposed to looking for patterns of behaviour, and coercive control is still a relatively new concept in all states and territories in Australia. So lawyers and judicial officers, we all need to do better at asking about all the litigation on foot and looking at the impact of that litigation in totality, and asking ourselves and the parties whether the instigation of the litigation and reports is in fact designed to coerce and control, and whether in fact lawyers and judicial officers are aiding and abetting the abuse, or at the very least aggravating it. Women remain reluctant to report family violence, and the women who contact us as services throughout our network often fail to recognise the behaviours they describe as family violence, especially when the abuse is not physical. The criminal law, while evolving, continues to look at each incident in isolation from the patterns of behaviour in relationships. So again, it was great to hear about the experience of the UK this morning in taking a more holistic look at that. Lawyers often also poorly particularise the patterns of behaviour in relationships, and I think that this is because we're not trained in it, and we all assume that the law applies equally to everyone. So we tend not to see the structural inequalities which have been recognised at international law for some time. Nor do we look for the power differentials and who has power over whom. We assume everyone is safe and equal, and that is not the case in Australia, as the statistics I've shared show. Again, this has been mentioned today, but misidentification of the predominant perpetrator is another problem under our state and territory laws. It's an issue that arises because of the incident-based approach, and sometimes the wrong person is seen as the primary aggressor by police and sometimes by the courts. Finally, the Commonwealth Government, since the last forum, has introduced a fund to pay lawyers within the private profession to take on Hague matters. This has been a welcome initiative. However, the tight timeframes that apply to Hague Convention matters, coupled with lawyers applying to the fund not always having adequate training at the intersection of family violence and Hague Convention, means it has not been successful as we hoped. In summary, abductions will not stop until domestic laws and responses are improved in the Australian context. This is a cultural issue, and if we continue to ignore women's experiences of family violence in Hague matters, this amounts to state-sanctioned systems abuse.